I want to talk about guerrilla warfare. The strategy in guerrilla warfare is that the weak attack the strong by picking their battles carefully. Smaller battles at first, battles they can win. That they count in the long term on the arrogance and brutality of the dominant force to bring itself down. And as they go along fighting small battles, they gather up what they will need for the climactic battle. In the struggle to close the Trojan nuclear plant, it was launched 20 years ago by a strategy of mass demonstrations, mass arrests, and accompanying some stunning legal victories. When 96 people who had sat inside the gates of Trojan and blocked the road were found not guilty in a Columbia County courthouse in the very shadow of the plant, Chief Counsel Ed Jones was asked, "How do you bring down a dinosaur?" And he said, "You do it with marbles." Nearly 20 years later, in 1993, after being weakened by 3 initiative campaigns, damaged by economic forces, and only 2 weeks before a major public hearing on the safety of the Trojan plant, PGE pulled the plug and the Trojan War was suddenly over. In fighting the Trojan War, my group became concerned about issues of ballot access and the integrity of the initiative process. We were concerned that great private enclaves, the malls, the Fred Meyer stores, had carved out these huge areas which were free speech free zones. There was no free speech there. And so we decided to challenge it based on the California Pruneyard case. We criticized what we saw as a lobotomized marketplace, and we told the courts that it would be their fault if the future were to be one of vacant-eyed teenagers with shop till you drop t-shirts. It was Lloyd Marbett who first brought in Jan Londahl to pursue these cases. Later, Mark McDougall, Lee Berger, Jeff Silver, the Lawyers Guild, all came in. In 1988, the Court of Appeals ruled in the Whiffen case that Lloyd Center had to put up with petitioning. And at that time, all eyes turned toward Fred Meyer because that's where the people are. Fred Meyer then went to the Multnomah County District Attorney, Michael Strunk, and said, "That case just deals with the large regional malls. There's never been a case in America that applied that to single freestanding stores. We want you to put these people in jail." They had a series of meetings with him, and to his eternal credit, Michael Strunk said, "No, I will give you one test case, and we'll take that up through the courts, but I'm not going to allow my prosecutors and my police to be dragged into a civil struggle." So our people went out. A half dozen of them were arrested at the Hawthorne store. I immediately gave them the moniker of the Fred Meyer Six. And that morning before court, I subpoenaed Cy Green, the chief operating officer of Fred Meyer, into court. And in his arrogance and his stupidity, he didn't give Charlie Hinkle a call. He just came. So I then led him through a series of questions, and he sat there as if these scruffy hippies and their commie lawyers can't do anything to me. And I led him through a series of leading questions, which he agreed to. And you will see them in the footnote in State versus Cargill in the Court of Appeals opinion. And that was the case that we wanted to go up on, the case that we made. Judge Ceniceros ruled that some Fred Meyer stores would have to put up with petitioners, that others wouldn't. On a technical burden of proof question, he found the defendants guilty. but it was a strategic victory. Fred Meyer's strategy in response was first to seek injunctions. And Charlie Hinkle knew what that meant, because you cannot enjoin the world. He said in exasperation to one judge, "I'll pick off every petitioner in this state and get an injunction against them one at a time if I have to." And so he did. And he'd get the word that there was a petitioner in Salem, and he would launch his great armada like a Roman legion, and they would go down to Salem. And he'd call me, "Kafoury, aren't you going to come here?" And I said, "No, you can handle this one by yourself, Charlie." And he'd put on this mountain of evidence against some poor unrepresented guy, and he'd get an injunction against John Vance. And then he'd call me up and say, "I've got an injunction, Kafoury. Are you going to appeal it?" I'd say no. And he'd get another injunction. He'd say, "Are you going to appeal that?" We'd say no. And we brought some court proceedings where we tried to get injunctions against them. They won them all at the trial court, and each time Hinkle would say, "Are you going to appeal now?" We'd say no. And in their frustration, they did something stupid, because we kept launching petitioners at them saying, "You really want to arrest people that the DA will not prosecute? You know we're going to take each one of these cases and put it on the shelf and put it on ice for a final decision. And if those are false arrests, we'll be back." Well, they didn't like that, and they were frustrated. And so they devised a strategy to continue arresting and intimidating petitioners without the risk of false arrest cases. And you ask how that can be done, and the answer, of course, is that it cannot be done honestly, and that led them to their disgrace and their ruin. In 1988, I had the perfect client, Kelly Peterson, the girl you all want your boy to marry. A hardcore anti-nuclear activist, but just a sweetheart. And she was arrested at a Fred Meyer store in Oregon City. I kept postponing her criminal trial until it was time for, until the Supreme Court finally ruled in the Whiffen case. And when the Supreme Court said, "Yes, now you've got the right to petition at Lloyd Center," then I breathed life into that criminal case. We went to the folding chairs courtroom of Judge Tom in the Municipal Court of Oregon City. And of course, once again, Hinkle wasn't there because he didn't know. Fred Meyer had sent some security guard to make their case. And kind of a story. They call the first juror. I'm there in my three-piece suit. And they call the first juror to come sit down, and it's Elmer Smith. They call the second juror, Elmer Jones. Man, I'm hiding my face, I'm biting my lip, and I say, I have this visions of an all-Elmer jury. And I say, you know, if they call one more Elmer, I'm just going to lose it. But they didn't. Now, the judge is a part-timer, the city attorney is an old semi-retired lawyer, and I said, well, geez, fellas, you know, we got this Lloyd Center case which says that it's no crime to do what this nice young woman was doing, and gee, you know, Fred Meyer wants to give her a criminal record. I don't really see the sense of that. Well, these two gracious gentlemen certainly didn't see the sense in that either. And a judgment of acquittal was entered. 3 hours later, little Kelly Peterson was in my office in front of 4 TV cameras saying, I was handcuffed and I was arrested and I didn't do anything. And it was on the evening news, and I was there saying, now we have the first court opinion to interpret the Lloyd Center case, the first trial court opinion on whether or not that applies to Fred Meyer. And let me tell you, if Fred Meyer should arrest anybody from here on out, they will be sticking their necks out because we will come after them for major punitive damages. Hinkle learned about this on the evening news, all right? 12 days later, a gallant lady, 68 then, 75 when the case came to trial, Lois Stranahan, was arrested at a Fred Meyer store in Portland. And She hurt her back a little getting into the police car. It was only about 4 lines worth in the whole trial transcript because this was a punitive damage case. She was held for about 40 minutes in custody. She had stood her ground, and that's why she was arrested. And that turned out to be the major case, the trial case. Later, as these cases continued in various forums, Kelly Peterson had another interesting experience. She was at one of the, she had been at a hearing when rules were finally established. After it looked like they were losing with the Cargill case in the Court of Appeals, Hinkle went to Judge Haggerty and asked for rules for petitioning so they could put some limits on petitioners. And the judge hacked down the rules that he proposed quite considerably. And Kelly Peterson, who was the plaintiff in that, who was the defendant in that case, took a copy of those rules and kept them with her in her purse. 2 years later, she was petitioning at a Fred Meyer store. This was a long struggle. 2 years later, and they came out and said, no, there's 4 people petitioning, that's against the rules, you can only have 2. And she said, no, it's not. I'm Kelly Peterson. It was my case. I have the rules here in my purse. Let me see your rules. And the rules she was shown were the draft rules, the ones which were refused by the court. What were they doing at a store? What were they doing being enforced? And so when we learned that, we put that into our bag and waited and hoped for the day that we would get before a jury. Then Mark McDougall and I were in a court hearing where Cheryl Perrin, the glamorous vice president of Fred Meyer, was led through testimony by Hinkle, direct testimony, in which Hinkle was trying to establish that there was no reason to hold Fred Meyer to having to put up with petitioners because they had separated themselves from the community. They were no longer integrated into the community. So we sat there and listened, as Hinkle said, has the company at times allowed the Campfire Girls to sell cookies and such? Yes, we have. Has the company been rethinking that position now? Yes, they have. What is your current position? Our current position is that we are not allowing any activity such as that on our property. Does that apply also to voter registration? Yes, it does. Have you received telephone calls from the Secretary of State's office concerning that? Yes, we've received phone calls from the Secretary of State, from the Multnomah County and the Clackamas County as well, and the League of Women Voters, asking you to rethink your position and to allow voter registration? Yes. What is your response? No, they cannot. I'm sitting here listening to this. They go on. The Union Gospel Mission has been criticizing them because they used to allow food bins outside the doors for people to contribute food for needy families at Easter. No more, because we don't want petitioners. And as I'm sitting there, I can see this transcript in my eye, blown up in front of a jury, and I'm saying to myself, do these people have any idea how this sounds, how bad it is? So I put that in my bag and waited. And then, just before trial, which had been delayed until the Supreme Court ruled in the Fred Meyer petitioning cases, the Cargill case. Just before trial, during depositions, I learned what that secret strategy was that they'd been pursuing. I didn't know they'd had one. How they had planned on arresting people without the risk of liability. You know what they did? They got an injunction against Lloyd Marbett. And they took a special security team which stayed at headquarters. And when that team got the call that there was a petitioner somewhere, they would take a copy of that injunction against Lloyd Marbett off the stack, head out to the store, show it to that petitioner and say, we've got an injunction against the court. It's right here. You're going to jail. Court says you got to leave. And if they were not intimidated, they would call the officers. And they would say, "Officer, we've got an injunction here from the court. Right here, do your duty. We got an injunction against petitioning." But there was one problem with that strategy. If the officer didn't buy into it, if he said, "No, you're going to have to tell me to arrest them, make this a citizen's arrest. I'm not going to do this on my own. You take responsibility for it." If the officer did that, then they had a problem. All this deceit was to no use. So they devised a strategy to deal with that. The strategy was to lie about it. He said, "No, that never happened. We never ordered any citizen's arrest. We told our people never make a citizen's arrest." So as trial approached, our job was to go back through this 10-year historical record and find the records of these arrests, to try and remember what hearing it had been in which Cheryl Perrin had said they let kids starve before they put up with petitioners. And so that was done. In deposition, or in voir dire, in the questioning of the jury, we first confronted this problem about Fred Meyer. And I did it this way. Everybody says they shop at Freddy's. How many people know that Freddy's dead? I mean, he was huge and he was always 100 years old and all that, but he's gone now. Who knows who controls Fred Meyer now? Juror. I know, it's controlled, I believe, by a New York syndicate. Got a gold star for that. Another juror, KKR, Kafoury. KKR, does anybody know what KKR is famous for? Juror, leveraged buyouts. Kafoury, leveraged buyouts. Did anybody see the HBO movie about them? Barbarians at the Gate? At this point, the judge cut me off and gave Hinkle 15 minutes to question jurors and then allowed me to continue. Now, I take something of a dissenting view on this whole idea about voir dire, and God knows my style is not for everybody. But, you know, Burl Green says the most you can hope for is to get rid of 2 or 3 of the dominant authoritarian personalities, and I agree with that. And I'm concerned that when we let them do the talking, as they all tell us to, you know, make yourself small and let them disclose themselves, that it's just too damn reminiscent of daytime TV. And all these people spewing forth all this wretched stuff about their spitefulness and their neurosis and their anger. And each of them feeding on it together. For what? Let me suggest, if you have a proper case, take control of voir dire like you take control of every other part of the case. You be the dominant figure in the courtroom. You do the talking. And if they'll let you make a speech, make a speech. Reach out to those people, knowing all that they bring in, and understand that it can all just be washed away if someone will inspire them and someone will treat them like the beautiful children they really are, tell them a great story, inspire them with talk of high values, and allow them to write the end to that story. Here is what I did, and this is a little long if you'll forgive me for it. We've all had experiences at Fred Meyer stores. Some of them have been positive. Some very nice people work at the Fred Meyer stores, which is not surprising. About every 5th person in Oregon seems to work there. It's an enormous empire and has lots of good people who work for it. And as we go about our daily lives, we like to think the best about people. We like to assume that they're okay. When somebody steps up to the stand, we like to assume that, they're folks like us, trying to do their best and just get along in life, and everybody, like Anna Frank said, is really good at heart. But it ain't necessarily true, is it? What do you think? Some people are not necessarily good at heart. Juror. Oh, I believe there's plenty that are not, unfortunately. Kafoury. And some kinds of organizations sort of make their own culture. And they pick who moves up and how far they move and how fast they move. And if they want to reward arrogance and nastiness and toughness, you're going to get a corporation which is arrogant and nasty and tough, right? I mean, that's the selection process that's going to be the result. And I'm here kind of as the bearer of bad news. Now, nobody likes to hear bad news. Everybody knows somebody like that, you know. Whenever they call you or come to see you, they want to tell you who's died or who's sick, whatever the bad news is. Well, I'm coming to you today as the bearer of bad news, and I want you to recognize that what I'm going to tell you through my documents and through my witnesses is not going to be welcome. Because everybody wants to feel good about Freddy's. And because we all know we're going to die within spitting distance of a Fred Meyer store, they're not going anywhere, and it's a lot nicer to feel warm and cozy when you drive by that big sign and say, yeah, that's my good neighbor's store. We're going to walk into this with an open mind and admit to ourselves that we don't know who runs this company. We don't know what goes on behind their doors. We don't know the conversations they have or what it sounds like. Can we all do that? And if I prove to you a pattern of absolutely willful disregard for people's rights, the political rights of petitioners, the political opportunities to be involved in politics that all the shoppers are entitled to, that all citizens are entitled to, if I prove that they have misrepresented court documents, if I prove to you that they have covered up their conduct in this case, if I prove to you that they have pursued policies which they have repeatedly denied under oath, if I prove to you that they were lying about it because they don't want you to know what those policies are, if I proved it to you, is there anybody who would say, I'm sorry, Mr. Kafoury, I can't award punitive damages against Fred Meyer. They're my neighborhood store. They're where I go. I just wouldn't feel right. I'm asking for $2 million when this curtain comes down. And that's not compensation. That's between you and them. If she proves her case, it's between you and them. And if you think they are that out of line, are you willing to do it? Are you willing to hit them as hard as they deserve? Is there anybody there who's going to chicken out if I prove my case? Tell me now. There was a woman on the jury, a strong-faced, middle-aged woman who had 2 sons, both worked at Fred Meyer, 1 union, 1 management. They were just coming off of a nasty strike. And so I chose her to answer the question. Mrs. Seidel, if you awarded $2 million, what would your son say? Mom, I work there. Huh? Would that be tough for you? Maybe a little, yeah. Kafoury, if I prove my case and you think they deserve it, will you do it, or will you pull your punches because of your boys? And she looked down thoughtfully, long and hard, and finally she said, I'd do it. Fred Meyer had 3 lawyers at counsel table. They left her on the jury. And she kept her promise. Everyone agrees that a trial has to have a theme. I suppose if I had a theme in this case, it would be they think they can get away with anything. Because as I read through the transcript, I see myself saying it a lot. But let me suggest to you that more important than a theme is a story. You gotta be a storyteller. And if you've got a great story and everything, all the evidence fits within that story, except for when they're lying, you got it. Because people like your story and want to believe your story and want to be able to retell your story. They want to come out of this with something. So I put Ken Fitzgerald on the stand, who told the story of how the initiative process was created back in 1902 in Oregon. Because the banks and the railroads were oppressing the people. The legislature was bought and corrupted. And old Ken looked like he'd been there at the time. And the jury was wrapped. And Charlie Hinkle said, "Objection, Your Honor. Let's cut this man off and strike his testimony." And the judge said, "Granted, stricken." And he had to get up, his big frame out of that chair, kind of confused at what had happened, walk out of the courtroom. And I whispered to myself, "Don't worry, old man. Charlie finished your story for you." We had cases, all the great petitioning cases were in evidence. They were in evidence to show Fred Meyer's bad faith. So I had all this great patriotic language to excerpt and to put up on the board saying, this isn't me talking about how important this process is, how much the public interest is served by this process, how it's the people's opportunity to sign petitions, which these petitioners represent. I had it all in language from the Supreme Court, from the Court of Appeals. Fred Meyer was the perfect dinosaur because we had by that time won 5 Supreme Court cases about petitioning. And the chief executive officer of Fred Meyer had never read any of them. He had never been briefed on any of them. He'd never been briefed on petitioning rights. And it was his belief that they had a right to throw petitioners out. And so I was able to say, well, you know, the Supreme Court can't get their attention. I guess it's up to you. There had never been any dissent. The top man had said, get rid of those damn petitioners. And everything else had been following orders. Nobody had ever sat down, according to their testimony, and said, you know, maybe we should rethink this. This is costly, it is losing, it's wrong. Nobody ever voiced such a notion. And so from there, it was all tactics, and their tactics were rough and they were dirty. I put on all their witnesses, and their high corporate officials swore that they had always taken the position that they never, ever did citizens arrest the petitioners. Well, I had an 8-foot shelf of petitioning files. I had all the arrest records, I had the transcripts, I had the hearings. I brought it in and showed every damn one of them was a citizen's arrest. Every one of them. I had Bob Cornett, one of their top security officials, who testified that after Kelly Peterson won her case in Oregon City, 3 months later I said, are you still arresting people for petitioning at the Oregon City store? And he said, we're still arresting petitioners at all our stores. Another time where you could just see that transcript being blown up and shown to the jury, and 7 years later it was. Cheryl Perrin took the stand and denied ever saying that they had cut off the poor, that they'd cut off people who wanted to register to vote, that they'd thrown out the Girl Scouts. She said, no, that petitioning rights was never a consideration, never crossed our mind, absolutely not true. Because they had never gotten the transcript of that hearing. We'd made the note of it, we'd gotten the transcript, so when she denied it, boom, there it is, all blown up. Put it in front of her. I read me and she read Cheryl. It was February, she came in looking elegant. The judge wrote a note to his clerk which said, her tan cost more than his house. And finally, the matter of the fake rules. She had this explanation about how she, copied the rules from Lloyd Center and just happened to write at the bottom, like they had in Lloyd Center, that this was an order of the court and anybody who violated would go to jail for contempt and so on. And that even though it was a draft, she was sure it would be approved, and so she sent it out to the stores, and after the final hearing she thought maybe she'd sent the real draft out, but she wasn't really sure and so on. It was muddled testimony, and she was, by that time, not being listened to. And so, in the final argument, I was able to set out that this was a company which had tried to avoid liability by deceiving petitioners, by lying about the significance of a court order. I said, they got an injunction against some guy who lives in Boring, and they're trying to say it's against the world, but they know that it's not. They know because they have a lot of smart lawyers. And when the officers would come, they would lie to the officers about the significance of the court order. And I explained all about when the officer uses his discretion to make an arrest, the company's off the hook, and if the company orders the arrest, then they're on the hook. I described what they were doing. I said it's as if they're shooting at the petitioner and they want to grab the officer and use him as a shield. So if somebody has to take the hit, let it be the cop on the beat. The question of where that strategy arose with the special teams and all that was, I think, in the jury's mind. And so I said to them, taking a glance at the three lawyers at counsel table, I said, this is a pretty sophisticated strategy. Do you think any lawyers were in the room when it was thought up? I contrasted the cowardice of their position to that of the petitioners. I said, people like Lois Stranahan, they say, I'm standing here, I think I'm within my rights. If you want to arrest me, go ahead, but it's not going to end here. Well, they weren't willing. They weren't willing to go along with that. They tried to lie their way out of it. And I said, look at what Mr. Cornett said. Even after Judge Tom had ruled that in his Oregon City, it was legal for petitioners to be at the Fred Meyer store, they went right ahead and said, oh no, we're arresting petitioners at all our stores. I said, that is stunning contempt. Here they lie to the police about court orders. They defy court orders that they don't like, and it works. Nobody does anything about it. So now they draft their own court orders. Why not? Use them to intimidate people. I said, we caught them doing that years ago. Nothing has happened. They are Fred Meyer. They think they can get away with anything. And the truth is that no one is big enough to hold them to account. No one but you. And the jury was true to its word. They awarded $2 million to Prayer in punitive damages. And looking back on it, in this extraordinary struggle, we still have only a razor-thin margin in support of petitioning rights at the Oregon Supreme Court. And Mr. Hinkle never got the case that he wanted. He wanted to go up for the big petitioning case on a case that was a record made by him with his witnesses saying what he wanted them to, with all those mountains of authority that he dumped on the table at each one of these hearings. That was the appeal that he wanted on his record, with him as the attorney. He didn't want to go up with some DA's record argued by an assistant attorney general in a criminal case. And now if the Stranahan case should eventually on appeal be the final word on petitioning rights in Oregon, it will be the case that Charlie never got, the case that he wanted. But his client did get the case that it deserved. Thank you.